Good afternoon. My name is Josh Blackman. I am the president and founder of the Harlan Institute. I am coming from you live from the CUNY Law School, where I'll be speaking in about 2 hours. But first, we have to hold the fifth round in the Harlan Institute Consource Virtual Supreme Court competition. This year, the tournament features Carpenter versus United States. We have two teams participating in this round. From Creekview Elementary, we have Aileen May and Amena. And from Lake Oswego High School, we have Laura Jiang and Alex Lee, and they will be discussing certain important Fourth Amendment issues for a case pending before the Supreme Court. I turn over to my good friend and colleague, Julie Silverbrook from Consource. Julie, thank you so much for hosting this with me.
Yeah, absolutely. We are really excited that we're now in our fifth of six preliminary oral argument rounds. It's been fierce competition so far. We're looking forward to seeing what the students from Creekview High School and Lake Oswego High School have to offer during this round. So I wish both of the teams the very best of luck.
Okay. And without any further ado, I will turn it over to the team from Creekview, Petitioners. You have 15 minutes. You may begin whenever you're ready.
May it please the court. Your honors, before we begin, I would like to address that I have a slight speech impediment, and if the court needs me to repeat anything, I would gladly do so.
Your Honor, my name is Amena, and along with my co-counsel Aileen, we will be representing the petitioner in today's case, Timothy Carpenter.
The issue before the court today is whether police can bypass the warrant requirement by the Fourth Amendment to obtain cell site location data pursuant to the Stored Communications Act.
Would this court benefit from a brief recitation of the facts?
Yes.
In April 2011, police arrested 4 men for armed robberies of a T-Mobile and Radio Shack. One of the individuals confessed to working with at least 15 men and gave police his cell phone number along with his accomplices.
The FBI searched through his cell phone and found other contacts during the time of his robberies. The FBI then proceeded to ask several magistrate judges for permission to obtain transactional records, which included toll records, call detail records, and cell site information at the beginning and end of each call.
The magistrate judges granted the government's application pursuant to the Stored Communications Act. Due to these searches, the police obtained evidence implicating Timothy Carpenter and Sanders and were charged with the violations of federal law.
Carpenter then moved to suppress the evidence obtained from the searches, and the United States District Court denied this motion to suppress the evidence.
At trial, Carpenter was convicted of 9 armed robberies and sentenced to 1,395 months in jail. The lower court refused to set aside their verdict, ruling that the government's compilation of Carpenter's cell site records was not a search under the Fourth Amendment. Therefore, a warrant was not needed.
Your Honor, today we will be arguing 4 points. 1, that the police search and seizure was a Fourth Amendment event, therefore a warrant was not needed. 2, 127 days is an unreasonable amount of days. 3, that the Stored Communication Act should not be applied to today's case. And 4, that the third-party doctrine should not be expanded to mobile data.
To address the first point, the police search and seizure in today's case was a Fourth Amendment event, meaning a warrant was required. As it became easier for the government to glimpse into our daily lives, the protection of the Fourth Amendment is becoming increasingly more important now than ever.
The Fourth Amendment protects the right of the people to be secure in their persons, papers, houses, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause.
The Fourth Amendment was ratified on December 15, 1791, which was 227 years ago, a time in which cell phones, more importantly, cell phone location data, were not an issue.
However, because of society's constant increase in technological change, we have to apply the Fourth Amendment to society's current fit, because not doing so would apply an old understanding to today's society.
Cell phone data is considered papers under the Fourth Amendment. In previous years, important documents were kept on papers and then stored away somewhere safe. But again, due to technological advances, people are able to keep these documents on their own cell phones, and therefore, these should be protected under the Fourth Amendment.
In order to obtain these papers, a warrant should have been issued. The respondents may argue that no warrant was needed. However, by ruling in their favor would be to allow FBI agents to impede on our Fourth Amendment right, which is something that the framers did not intend on doing.
Counselor, can I interrupt you for a second, though? Because you did have a magistrate judge weigh in here and say that the FBI could look at the cell phone data. Did you not?
Yes, Your Honor.
So are you arguing that that's not enough, that you need to go and get a warrant?
Yes, Your Honor.
Okay, and where do you draw the line? When is it okay under the Stored Communications Act to do the magistrate procedure versus when do you need to go and get a warrant? Help us draw a line here.
Well, Your Honor, it's our contention that the Stored Communication Act should not be applied to today's case because it's the petitioner's contention that it's trying to surpass the Fourth Amendment due to the characteristics that the Fourth Amendment has that the Stored Communication Act does not. It's just being used to get rid of the Fourth Amendments, like warrant requirement, probable cause requirement, and oath and affirmation requirement.
So what are you asking us to do in this case? Do you want us to overturn the Stored Communications Act?
Your Honor, we are asking this court not to apply it to today's case.
Okay. You can continue.
In looking at the Fourth Amendment, we look at the test set forth in Cass versus United States. In order to determine whether there's an unlawful search, we must look at two factors. One, whether the parties exhibit a reasonable expectation of privacy. And two, whether the expectation is one that society is prepared to recognize as reasonable.
Applying the first prong to today's case, Carpenter did have a reasonable expectation of privacy. According to the ruling in Rackass v. Illinois, the expectation of privacy must have a source outside of the Fourth Amendment, either by reference to concepts of real or personal property law or to the understandings that are recognized and permitted by society.
As mentioned beforehand, cell phone data records are protected under the Fourth Amendment. Because of the severity of importance that these range from, a reasonable expectation of privacy is expected with every cell phone user.
If the courts do not grant this reasonable expectation of privacy, the government would be allowed to search through cell phones anytime they please, and in the end would lead to more convictions based off of rights provided by the Fourth Amendment that would no longer be granted to us.
Counselor, opposing counsel in their brief brings up the third-party doctrine that in this case, Mr. Carpenter voluntarily used his cell phone. He signed a contract which explained to him that T-Mobile, his cell provider, would have access to this information because that's the way that cell phones work. How should that factor into our determination of whether or not there was or should have been a reasonable expectation of privacy in his cell data?
Your Honor, it is in the petitioner's contention that the Stored Communications Act should not be applied in today's case because it's trying to surpass the Fourth Amendment. The third-party doctrine also said you should be able to get documents from a third party, but in the case presented before the court today, the level of intrusion between different documents are different because you have your cell phone every day, so it has more personal stuff on your cell phone than all your bank records and your bank statements.
So should it matter to us?
Counselor, if I could, I'm sorry, if I can interrupt briefly, if you're right that technology changes so quickly, why shouldn't this court wait for Congress to perhaps amend the Stored Communications Act? Right? Why should it be the role of this court to change Fourth Amendment law when maybe the legislative branch is better suited for that role to develop new practices for evolving technologies?
Well, Your Honor, because it's our contention that we believe that they should update the Stored Communication Act and third-party doctrine, we do not believe that those old acts should be applied to today's case, especially when this case is centered around our technology increasing in today's society.
Counsel, let me ask you a follow-up question because you're saying that there is a specific sensitivity to this data. Can you tell me a little bit more about the data that was captured in this case and how it might be different than the GPS data that was central to the U.S. v. Jones case?
Yes, Your Honor. When we take a look at the United States v. Jones case, it held that GPS monitoring over a long period of time is unconstitutional. Your phone and GPS both track your position, even if the GPS tracker is more precise than the location data. In today's case, even though one is more precise than the other, they both track your location and are easily accessible to the government. So since the circumstances are similar, the court should follow the ruling in United States v. Jones in holding that, Your Honor, in holding that GPS monitoring over a long period of time is unconstitutional.
Okay, you continue.
The government obtained 127 days worth of information to convict Carpenter for the robberies on the dates that they occurred, not a time span in which it encompasses.
If we apply the reasonable man standard, a reasonable person can come to the conclusion that taking 127 days worth of information is highly unreasonable.
The 127 days worth of information exposes more personal information than it will information that will help with Carpenter's conviction. more than the telephone numbers in Smith versus Maryland, and more than the financial documents in United States versus Miller.
Counsel, let me interrupt you again. So 127 days you're saying is unreasonable, and maybe we're open to that argument. But certainly some amount of monitoring when you have somebody who has testified to the fact that Carpenter was involved in a crime is acceptable. So is there any amount of time that the FBI could use the CSLI data to monitor Carpenter's position that would be reasonable in your view? Or is it always unreasonable unless and until you get a warrant?
Well, Your Honor, there could be two answers to this question. The first one is that because there is no case law that strictly says you only can monitor this period of amount of days, it is up to the courts to determine that ruling, as well as they could take the days of like when they exactly know, like, hey, you were here on this day, you were here on this day, instead of just taking 127 worth of days of information looking for evidence. And secondly, as Your Honor mentioned, we do not believe that taking 127 days worth of information or any amount of days is reasonable because there was no warrant in today's case. Your Honor, the next point we will be arguing is that the Stored Communication Act should not be applied in today's case.
According to the Stored Communications Act, a court order may be issued only if the government offers specific and articulable facts showing that there are reasonable grounds to believe that the contents or wire or electronic communication of the records or other information sought are relevant and material to ongoing criminal investigation.
As previously mentioned, Your Honor, it's our contention that the Stored Communication Act should not be applied to today's case because it is an attempt to surpass the Fourth Amendment. The Stored Communication Act lowers the standard for police officers to search through cell phone records.
When applying the Fourth Amendment, probable cause is needed to get a warrant to search through papers. However, the respondents claim that this act is sufficient enough to search through contents of a cell phone.
If this act could be applied to cases such as the one beforehand, it would create no need for the Fourth Amendment, and in the end would allow police officers to again search through the contents of a cell phone without a warrant.
This act cannot be taken advantage of as a reason to bypass the Fourth Amendment. If we focus on the words of the Fourth Amendment that read, "No warrant shall issue but upon probable cause supported by oath or affirmation," and then looking at the Stored Communications Act that says specific and articulable facts showing that there are reasonable grounds.
We can see that in the Fourth Amendment, probable cause is needed, and in the act, reasonable grounds need to be shown. Reasonable grounds is far less of a burden of proof than probable cause supported by oath or affirmation.
The Stored Communications Act is an attempt to bypass the Fourth Amendment's three-part requirement. That 1, there must be probable cause. 2, probable cause is needed for a warrant. And 3, it must be supported by oath of affirmation.
Because the Stored Communication Act only requires reasonable grounds instead of probable cause, it lowers the standard from the Fourth Amendment. The Stored Communication Act also lowers the bar even more by not being clear on what they mean by reasonable grounds.
The second requirement is that a warrant is necessary, and as mentioned previously, no warrant was issued. Better yet, the respondents are using this act as their own excuse to not get a warrant.
Moving on to the third requirement of the Fourth Amendment, the oath or affirmation. The Stored Communication Act does not have this in its requirements, and by not having one would not allow people to have a due process protection the Constitution sets up for us. So not only is it violating...
Counsel, if I could interrupt briefly, were they recording the contents of his phone calls?
Your Honor, do you mind repeating your question? It cut out.
I'm sorry. Were the police or the FBI recording the contents of his phone calls or the contents of his text messages?
Your Honor, the only information they received in today's case was the cell phone tower records.
Right. So maybe there should be a different standard between the actual contents of the communication, right, the voice, what we're talking, and the cell phone data, the CSLI data. Why should the Fourth Amendment apply equally to the contents of the communication than from the information about where the person was? Wasn't he out in public? Why? Maybe we should treat that information differently.
Well, Your Honor, it's our contention that all contents of a cell phone, whether it be messages, data, anything should be constituted as papers under the Fourth Amendment, and therefore any contents, any data you want of a cell phone needs to have a Fourth Amendment, or it needs to have a warrant, excuse me.
Even if the court were to rule that there was reasonable grounds and that the magistrate judge's permission counted as a warrant, it would still fail because nothing in the record shows that the government officials were sworn under oath and testified in court. Because the Stored Communications Act is extremely vague and because reasonable grounds is not defined, we cannot apply the Stored Communications Act in today's case.
Your Honor, our last and final point we will be addressing is that the third-party doctrine should not be expanded to mobile data. However, because we are on a time constraint, this will be a very brief point. In 1967, the Supreme Court pronounced in caps that what a person knowingly exposes to the public, even in his own home or office, is not a subject to Fourth Amendment protection. This rule that a person has no legitimate expectation of privacy and information he turns over to third parties is known as the third-party doctrine.
The respondents argue that cell phone users assume the risk when handling information over to third parties. However, people do not assume the legal risk as a matter of deduction, but assume only those risks of unregulated government intrusion that this court tells us we have to assume. In a society that's becoming more developed technologically, it is crucial that whatever is in our technology or cell phone stays confidential. Today, we have shown that this case is a Fourth Amendment event, therefore a warrant was needed. The Stored Communications Act is an attempt to bypass the Fourth Amendment. That third, 127 days worth of information is unreasonable. And fourth, the third-party doctrine should not be expanded in today's case.
Your Honor, it is for these reasons that the petitioners ask that this court rule in favor of the petitioner, Timothy Carpenter, and overturn the lower court's decision. Thank you.
Thank you. Josh, you're still on mute.
Sorry, I said a minute, but I was on mute apparently. So I'm sorry. I'm actually in Queens right now, New York. I'm about to speak at CUNY Law, so there's a little bit of noise in the background, so I have to mute my microphone. Sorry about that. So I'm going to put the petitioners on mute. Respondents, you now have 15 minutes, and whenever you're ready, you may begin. Okay, you're still on mute.
All right, can you hear us?
Yes, we can, and you begin whenever you're ready.
May it please the court that I, Laura Jiang, and my co-counsel Alex Lee represent the respondent today in the case of Timothy Ivory Carpenter, the United States of America. May it please would the court like a restatement of the facts?
The facts of the case are as follows. Timothy Ivory Carpenter was implicated in a series of crimes in Ohio and Michigan over the course of 127 days from a fellow accomplice. The FBI requested a search of transactional records provided by cell phone providers through multiple magistrate judges who authorized the search. So the respondent argues that the Stored Communications Act is constitutional because it recognizes the diminished expectation of privacy, specifically concerning transactional records. We have four distinct arguments.
The first is that under Katz, there was no violation of the subjective privacy expectation or societal expectation of privacy. The second is that the third-party doctrine, transactional records, and the Stored Communications Act all lead to a diminished expectation of privacy. The third is that the FBI acted legally and constitutionally in the manner in which they proceeded to gather the petitioner's data. And lastly is that the court should defer to Congress on emerging technological challenges in commercial activity.
Starting with the first argument in regards to the specific expectation of privacy, Katz sets out a standard with a two-pronged test. That is the individual and societal expectation of privacy. We'll answer this by saying that first, the individual expectation of privacy simply doesn't exist. The petitioners argue that because the respondents argue because the terms of service agreement is present and that the petitioner had to sign it before obtaining a cell phone, that means that the individual expectation of privacy is non-existent in regards to cell phone location data.
Counselor,
Secondly,
can I ask you a question? Do you own a cell phone?
I do.
Did you read the terms and conditions before you purchased your cell phone?
I did.
You did? And did you understand that in using your cell phone that your cell data would be shared with a third party, the cell phone company?
Yes.
Okay. Do you think that most Americans have read their cell phone contract and understand that?
No. That being said, we believe that the terms and service agreements, the fact that you have to agree to those means that the individual expectation of privacy still does not apply to transactional records.
But if the average American citizen is unaware, right, that they're sharing this data every time they use their cell phone, Can that be reasonable? Can they actually have no reasonable expectation of privacy? My bet is if you ask the average American citizen, they would think that they are not sharing that data with a third party.
The average American citizen can be expected to know that when you at least are dialing a different number or sending any form of communication to a different person, that you are necessarily connected to their cell phone tower in order to pass that message along. In other words, you are necessitating a third-party communication through the process in which the action is carried out.
So are you arguing that it doesn't matter if they actually do know, it's that they should know?
Yes.
Correct.
Okay, proceed.
The second prong is the societal expectation. And the respondent argues that the societal expectation doesn't exist when the business records are involved, specifically because business records are held by the business to conduct business practices. The transactional records, there is no societal expectation that transactional records and these business records are held by the individual. Yeah.
And additionally, this was confirmed in Smith v. Maryland when the court writes that these business records are actually held for legitimate business purposes, and that the subscriber should logically and rationally realize that these records are not exclusively owned by the subscriber themselves, that they are originally part of the telephone company's ownership. This was again confirmed in New York Telephone Company, or United States v. New York Telephone Company, where they allowed the court, or where the court allowed for court orders to install pen registers on phones in order to collect solely the content, in order to collect solely the phone numbers and location data transferred through these calls, but never the content. Because of the distinction between the content of the calls and the data that is transactional data collected in this case, it's important to distinguish that there is a lowered expectation of privacy because the FBI is never looking into the content of the calls, only the transactional records obtained.
That brings us to our second argument, which is specifically that of the third-party doctrine and the Stored Communications Act. The petitioner argues that the third-party doctrine and the Stored Communications Act do not apply because they are used to circumvent the Fourth Amendment. We agree that the Stored Communications Act was used to circumvent the Fourth Amendment, but we believe that that's the point. The Stored Communications Act was implemented to give law enforcement a way to actually search specific transactional records and stored communications via the magistrate judges and via the legal channels that were used by the FBI.
Let me ask you, when was the Stored Communications Act passed?
1986.
Do you feel like a law that is that many years old, it was a time when few, if any, had cell phones, does that need to be updated to reflect modern technology? Cell phone use is pervasive. People do a lot on their cell phone, including things that are private in nature. Does that matter at all in our analysis in this case?
Absolutely, it matters. But we're saying that there's a distinction between the content of the data and the actual transactional records of the data. The Stored Communications Act is specific in its, it is a narrowly tailored act to give law enforcement the ability to look at transactional records. And second, it has a compelling state interest. So because it is specifically used for transactional records and exactly the way the FBI used it in Carpenter, the United States.
So you think that there's a distinction between the content, right, and these kinds of transactional records. But what kind of information can you get from the kinds of transactional records they were looking at in this case? They have a pretty good sense of geographically where Carpenter was. They may actually know the phone numbers. So if he's calling his doctor, for example, we can have a sense of what the content of those conversations might have been. You're saying none of that should matter.
We also think, rather, the respondent also thinks that the Stored Communications Act itself is still a functionally good piece of legislation because it has certain protections put in place. For example, it raises the basic subpoena requirement given by courts with more protections. It prevents other more intrusive third-party records, for example, like credit card transactions or billing services or health records from being accessed without a further process by the government, and also prevents these cell phone companies from giving out data willingly to government agencies without an actual reason indicated in the Stored Communications Act, and that The protections in the Stored Communications Act also require a neutral and detached magistrate judge and factual basis for why these records are necessary, meaning that there is built-in protections from the Stored Communications Act.
So, Counselor, let me just ask one more question. So if they could go to a magistrate judge under the Stored Communications Act, which was written a long time ago, technology has changed. You can glean more information from cell phone use today than you ever could before. In fact, this case happened so many years ago that actually cell phone location data is actually much more precise today than it was when Carpenter was being monitored. Why can't they just go and get a warrant? If they're already going through the hassle of talking to a magistrate judge, why not just take it one step further and get a warrant? That way you know you're 100% compliant with the Fourth Amendment.
We don't know specifically why the FBI did not get a warrant, but we believe that the magistrate judge is enough of a judicial authority to authorize such a surveillance.
Especially with such a minimal intrusion that was conducted in this case, where it was just a general location data and never actually accessing the content of the calls, the process in which the FBI carried out the action was sufficient. The third argument here,
Counselor, if I could interject briefly, how many days of data was collected for this search? How many days are we talking about?
127 days.
Which is 13 less than allocated or allowed to be surveilled by the Stored Communications Act.
No, I get that's okay under the SCA. You know, we have to write an opinion, right? What line should we draw? How many days is too many days for a search to be reasonable? Would you say if we get 180 days and we renew it every 6 months indefinitely, we could track someone for life? Would that be permissible?
We believe that that's permissible based on a case-by-case basis. Specifically, Carpenter v. United States.
But you think a reasonable search is an indefinite search for the rest of a person's life without a warrant?
The respondent argues that it depends on completely on the case. That specifically in Carpenter's, in this case, that the 127 days was reasonable.
It's also difficult to presume hypotheticals, which is why the case-by-case basis is necessary, and that the court should be looking at the case and the facts as they come, and rather staying away from trying to determine hypothetical situations, because that's not what the scope of the case pertains to. May we continue? Our third argument is that the FBI acted procedurally, legally, and constitutionally. In the Katz opinion, the court wrote that had the FBI acted with the permission of a duly authorized magistrate judge, the surveillance that was carried out and the data collected in Katz would have been permissible, again, only if they had contacted a magistrate judge before they had carried out the surveillance. Because of this, with such a minimal intrusion that was carried out in the case of the petitioner, the minimal intrusion here allows for the Stored Communications Act to be a plausible and constitutional manner in which the transactional records for the petitioner were collected.
The fourth and final argument is, I think, a very important one. The respondent thinks is a very important one, which is the deference to Congress, the deference to legislative authority on questions of a case-by-case basis. Specifically, on the case-by-case basis, the respondent indicates or argues that the way that every single case should not be, or the way that every single case operates in the status quo should not be blanket ruled on by the Supreme Court, that each region is different, every state's different, every case is going to be different. And we believe that the Supreme Court ruling on such a big matter in such a sweeping way, assuming that the Stored Communications Act and the third-party doctrine and Miller are all unconstitutional, would be a complete overreach of judicial power and completely destroy the ability for law enforcement to actually use the power that they have in the status quo.
With the intricacies of legislation, including the Stored Communications Act, it's necessary for Congress to act in order to draw these specific boundaries and lines that the court is asking questions about. In terms of how Congress would carry these actions out, it would be through the Commerce Clause, which has been used in order to carry out a variety of other different legislative acts. In the case of sweeping constitutional barriers to unreasonable search and seizures, we can see that even if the Stored Communications Act may be seen as if the Stored Communications Act can be seen as broad, it's still not as broad as many founding fathers may have not as broad as many founding fathers would.
Well, let me go back to a point I raised earlier. You're basically saying that so long as the police comply with the Storage Communications Act, they can basically follow someone indefinitely without a warrant. How is that different from the notion of a general warrant or writ of assistance, which our framers were very much concerned of?
That brings us again back to the narrowly tailored policy, specifically the Stored Communications Act and the compelling state interest that is the Stored Communications Act. We believe the Stored Communications Act is a good standard for law enforcement to be able to defer to, specifically because it requires judicial authority. It requires somebody well-informed of the facts of the case and well-informed of the investigation to actually...
But if they're so well-informed, why can't they just obtain a search warrant? Why can't they just go to an Article 3 judge and request for a warrant? Why should they get, the skim milk version with the magistrate judge?
The respondent would indicate that they could do that, but the Stored Communication Act is both constitutional and legally efficient for the FBI or the police to be able to gather surveillance.
Especially because it does recognize those diminished expectation of privacies for transactional records.
Yeah.
Okay, and you have a minute left, counsel, if you want to wrap up.
So in summary, the Stored Communications Act is completely constitutional, specifically because, again, it recognizes the diminished expectation of privacy for transactional records due to the nature of the third-party doctrine and the legislative act itself. There was no violation under Katz of the selective privacy expectation or a societal expectation of privacy either, because, again, of the process in which the data was obtained and the fact that consumers and subscribers have limited control over those transactional records, and again, that they are owned by the businesses themselves. And lastly, that procedurally, the FBI acted constitutionally, and again, that we should defer towards Congress in terms of deciding these precise questions of where the boundaries should be drawn. Thank you.
Okay, with 5 seconds to spare, I will yield the balance of your time. Please put yourselves on mute, and we will switch back to the petitioners. You have 5 minutes for rebuttal. You may proceed whenever you're ready. Oh, you're still on mute, petitioners.
You're still on mute.
There we go.
No, they're still on mute. They gotta, yeah.
Okay.
Good?
Yep,
I
perfect.
think so.
And we will restart your time.
Yeah, I didn't even start the clock yet.
All right.
Okay,
Now you may
petitioners, whenever you're ready, you may begin.
May it please the court. The petitioners will be addressing 2 points on rebuttal. 1, that there is a reasonable expectation of privacy, and 2, that the Stored Communication Act should not be applied, or at least it should be modernized to today's society. To address opposing counsel's argument that there is no reasonable expectation of privacy, it is highly unreasonable to expect a reasonable citizen to not carry a cell phone, even if they signed off on a contract. Even if the citizens know they are being tracked, the petitioner's contention that a warrant is still needed to get that information. To address the second point, that the Stored Communication Act should not be applied, it was the petitioner's contention that there was a minimal amount of intrusion. However, the intrusion in today's case is more personal than the phone numbers in Smith v. Maryland and the financial documents in United States v. Miller. The opposing counsel also mentioned that this should be taken by a case-by-case basis. However, we contend that no amount of days is reasonable if it doesn't pass the Fourth Amendment. As previously mentioned in our arguments, and Your Honor mentioned how many days would be sufficient. It's still our contention that there is no amount of days because they needed a warrant to search our cell phones, no matter how many days it needs. So
Counselor, I'm sorry if I can interrupt briefly. Is it your position that all searches performed under the SCA are unconstitutional? Is that what you just said, that no duration of time would ever be permissible without a warrant? Is that your position?
Not, Your Honor, it's not in general that we are stating this position. However, in today's case, we are.
Well, yeah, but a minute ago you said that no duration. So what would an acceptable duration be? 24 hours, a week, 10 days? I mean, what would you be okay with?
Well, Your Honor, there is no case law that defines how many days or hours.
I know that's what we're doing here. That's why I'm asking. What line would you give us?
Your Honor, the line that we would give is the exact days that the police know that the crimes took place.
Okay, so if you know the crime took place on Tuesday, March 30th, that's the day you can search for that. Only that day, no more.
Yes, Your Honor.
Okay, proceed.
Your Honor, it was also the petitioner's contention that, excuse me, Your Honor, it was the petitioner's argument that it was the Stored Communication Act was used to overturn the Fourth Amendment. So even though it did apply, it wasn't as advanced as it was in, excuse me, Your Honors. When the Stored Communication was written in 1986, the technology was there. However, it wasn't as advanced as it was in today's case, 2011. And therefore, even though it did apply to the past, it should be changed and applied to today's case more differently than it did in the past. So it is our contention that it should not be applied because of the fact that technology is way more advanced than it was, let's say, a year ago or 2 years ago, or even 1986 when the Stored Communication Act was applied. So as society is changing and technology is getting more advanced, it is our contention that these acts should be updated with the times.
Well, Counselor, if you're talking about updating statutes, isn't that something Congress is uniquely qualified to do? We don't update statutes. That's a role for the court, the legislature.
Yes, Your Honor. It is a job for the legislature, and which is why it's our contention that this court should not view the Stored Communication Act in their ruling and should instead not apply it to today's case.
Okay. Counselor, about a minute and a half. You want to wrap up your remarks?
If this court chooses to rule in favor of the petitioner, Timothy Carpenter, it would set a strict set of guidelines in order to search someone's phone. This will reinforce the constitutional mandate that dictates you cannot search someone's phone, papers, and effects without following all the guidelines set forth by the Fourth Amendment. Based on the oral arguments heard today, we pray that this court rule in favor of the petitioner and overturn the lower court's decision. Thank you.
Thank you very much, Counselor. Okay, we'll put you on mute and we will go back to the respondents. Respondents, you have 5 minutes of argument time. For rebuttal, you can begin whenever you're ready.
If it may please the court, at the end of this case, you have to be asking the question of whether or not the intrusion was minimal enough or distinguishable enough from those of previous cases. The respondent argues that the case-by-case basis, specifically when applied to Carpenter, was a minimal intrusion in accordance with the Stored Communications Act and thusly in accordance with the law. The petitioners offer no bright line on whether or not the Stored Communications Act or any other law is able to be constitutional. We believe, or the respondents.
Can I interrupt you for a second? Because literally a minute ago, they gave you the circumstances in which it would be okay. They said, it's okay if you follow the procedures of the Stored Communications Act, if you just track that data for a single day, the day that you suspect this person committed the crime.
So the respondents would argue that that would not necessarily be the most useful information for certain investigations, that investigations last more than just 1 day, that the Stored Communications Act, as it stands in the status quo, is able to encompass investigations in totality and able to actually help law enforcement do their best and most efficient work.
In addition, it was a series of robberies and not just a single robbery. So the stream of data that was collected here was necessary in order to help the FBI actually track down the robberies that were occurring.
In 2 states, no less. So we believe, or the respondents argue, again, that the legislation is key. The petitioners concede that legislation is going to be the important factor at the end of this case. And we believe, or the respondents argue, that our fourth argument is very key to this decision, that the courts should be deferring to Congress on whether or not this question is going to be applied to future cases or future investigations, that an overarching and sweeping judicial opinion would be irresponsible of the court. They say, or the petitioners argue, that everybody carries a cell phone and therefore there is an expectation of privacy. But again, the respondents would rebut that by saying that the terms of service is indeed a check back against this societal ignorance that we believe.
Right, but Counselor, but the terms of service, I mean, if you look at the CATS test, right, the CATS test asks whether whether an expectation of privacy is objectively and subjectively reasonable. Let's say we took a poll of Americans, right, and we said, I'm guessing, 75% of them would say, we have no idea that the government can track our data. Shouldn't that inform whether there's a subjective expectation of privacy?
The respondent would argue that that should not inform the subjective expectation of privacy because, again, people should be they should understand that the terms and service agreements essentially minimizes their intrusion, or minimizes the ability of, or minimizes the types of surveillance that can be done by the federal government, that the transactional records, that the cell phone location data is not owned by the customer.
And again, that previous court cases have affirmed this. In other words, Smith v. Maryland, where the court wrote again that transactional records are again not exclusively owned by the consumer or the subscriber, but rather that they are pertained and obtained by the business for legitimate business purposes.
Finally, the last question the respondent asks to essentially resolve is the constitutionality of the Stored Communications Act. The petitioner indicates that the past is no longer relevant, but the respondent will rebut by saying that the past is still very much relevant, that the Stored Communications Act is specific to stored communications, those being the third-party communications, those being the third-party data, that third-party data that is accessible by the FBI. We believe that
About a minute left.
Oh, okay. That the specific narrowly tailored act and the
State interest.
The specific state interest of the Stored Communications Act is going to be key at the end of this case.
So when considering whether the warrantless search and seizure of 127 days of data, including location data and transactional records, is unconstitutional, it's clear that the answer is no, because the Stored Communications Act is constitutional in and of itself, because it again recognizes the diminished expectation of privacy in regards to transactional records, and again that these transactional records are never exclusively owned by the subscriber or the customer, but rather that they are owned by the business for legitimate business purposes, and that society should recognize that these records exist outside of tracking purposes.
Okay, with 2 seconds to spare, very good. Your teams are very much on time. I'd like to say thank you both to both teams from Oregon and Texas. You did a fantastic job. You make us very, very proud. All too often in our society, we can be very pessimistic about the future of a republic, but I am confident that with people like you leading the way, we have a bright, bright future ahead of us. Julie, is there anything else you'd like to add?
No, I just want to echo what Josh just said. We are always so amazed by the students who participate in this program. They get better every year. You both teams did a fantastic job. The last round of the competition is in the next hour, and then we are going to select our top teams to participate in our championship round, which will be on April 26th in Washington, D.C. at the Georgetown University Law Center in their moot court room, which is a mock-up of the U.S. Supreme Court. And we will let you know either later today or early tomorrow whether or not either of the teams present here will be advancing to the next round.
Yeah, and we already have a panel of at least 3 federal judges who will be grilling the winners. But with that, I want to thank you both, and court is adjourned.